What followed was a dispatch of the attack pack led by Lieutenant Colonel David Crane, Defense Intelligence, 30 years, prosecutor. He, Crane, unlawfully unsealed the court's sealed indictment to his handlers, senior U.S. government officials at the U.S. Embassy in Freetown, and was never held to account. The rest of the operational team are Colonel Brenda Hollis, Defense Intelligence, CIA, U.S. Air Force, Senior Trial Counsel, and Armed Prosecutor. James C. Johnson, U.S. Army expert, 20 years on conventional and special operations, Chief of Prosecutions for the SCSL. Alan White, 30 years Defense Intelligence, recalled from retirement to head up investigations at the Special Court of Sierra Leone.
This was after the conviction. The verdict had been given, okay, but this was during the sentencing procedure. And when they had convicted him of 11 counts, of all 11 counts that we had charged him with, and a couple weeks after that was announced, then both prosecution and defense had the opportunity to make sentencing submissions, both written and oral. And so we had done that, and now it was time for oral submissions on sentencing. And the defense attorney had made submissions on behalf of Charles Taylor, and then Charles Taylor had 30 minutes to speak on his own behalf regarding his sentence.
Jim, what were you thinking when Charles Taylor, you didn't know what he was going to say, calls you out?
I don't know. I guess it was certainly a theme throughout the trial was that he was basically a victim of the U.S. and the U.K. in being tried in the first instance. And I don't know, I guess it was kind of a combination of, gosh, he didn't forget about me. And so maybe a little bit of that, and then the rest of it was probably just the rhetoric that we have heard before throughout the course of the trial. And he did. And of course, this was his way to try to show that, you know, certainly senior members of the prosecution were Americans, and his attempt to show that we were indeed a conspiracy on behalf of the U.S. government all along.
And he really, first at the beginning, really started off lashing into David.
Yes, that's right.
What was the main pretext there? When he started going through executive orders, and all of a sudden kind of went after David and David's testimony in front of the...
Well, he was, I mean, the real idea, and of course you know, this was too late in many instances because he had been found guilty at this point in time. This was a sentencing hearing that he was talking about, but this was his chance to go through these issues again. And he had tried very hard throughout the trial to show that the first prosecutor, Dave Crane, was indeed discussing and taking instructions from the U.S. government as the indictments were brought forward, which indeed could have been anything from the truth. In fact, the first prosecutor was not a friend of the U.S. government at the time that he unsealed the indictment, but that was his way to try and show that first prosecutor, that all of the prosecutors were indeed taking instructions from the U.S. government on this trial.
And interestingly enough, when he goes down the roll call, he misses and forgets to talk about the guy in the middle, Sir Desmond de Silva from Great Britain. He talks about David. He talks about Stephen Rapp, who, because he was a prosecutor, is now rewarded by becoming the United States Ambassador for War Crimes. Also another Chautauquan. Steve has been here several times. And then, of course, Brenda Hollis.
I can only assume that the focus of this was against the U.S., and Sir Desmond de Silva was from the U.K.
Part of just again, to keep a chronology of things, Taylor was indicted in March 3rd, 2003, and chief prosecutor was David Crane. And Taylor at the time was a sitting president of Liberia. Were you on the staff then?
Yes.
There's a point where you have to make a decision, staff has to make a decision that you will unseal the indictment, and the timing of all that. What was going on behind the scenes?
Well, this was the first time since the indictment that Charles Taylor had left Liberia. And we knew, of course, that unsealing the indictment while he was in Liberia would not get him arrested, would not get him turned over to the court, essentially. We knew that Liberia would not comply with our arrest warrant and arrest their own president and turn him over to us. So he left the country. And so this was the first shot that we really had at where he would be in another country, somewhere outside of Liberia, and the hopes that where he was at would enforce our arrest warrant and arrest him and turn him over to the special court.
And he was in Ghana.
He was in Ghana. He traveled to Ghana for a peace conference. That was, of course, there was a horrible conflict going on in his own country, and the rebels within his own country were at his doorstep. And that probably encouraged him to come to the bargaining table. And a peace conference was set up between him and the rebels out of that country, and it was set up in Ghana. And so he left the country, and that's why the indictment was unsealed at that time.
So they're really in Ghana at the time, the fellow African colleagues, heads of states, were trying to convince him for him to step down.
Yeah.
And then at the same time, you got somebody who's going to actually hand him a piece of paper. This is right out of Hollywood. How did that happen? I mean, when you serve an indictment, you got to...
Yeah, it was, I mean, the first step, of course, was to serve the indictment, or the indictment and the arrest warrant, onto the authorities in Ghana.
Okay.
And then it would be up to them to decide whether or not they would enforce our indictment or not. They were under no legal obligation to enforce our indictment. Our indictment legally was only enforceable within Sierra Leone without the Security Council taking some action and putting their weight behind it. So there was no legal obligation on Ghana to enforce it, but we would certainly have said that there was a moral obligation on the government of Ghana to enforce the indictment.
So Ghana's handed the piece of paper to enforce, so you actually served it on some officials of Ghana. How did the word get out that had actually occurred? Did you announce that?
Well, you've got to distinguish, at least within the organization of the special court, serving the indictment was the responsibility of the registry. And they were the ones that would formally serve the indictment. And I'm trying to remember, of course, David Crane unsealed the indictment.
What's that really mean? What's that really mean?
Yeah, making it public.
Okay, yeah. Okay.
Yeah, that it was sealed means it's just, it's not a public indictment, only those few within the court know about it. And so the indictment was made public. And I wish I could, and I cannot remember the order of how the indictment was served on Ghana. I just don't remember.
What, did Dave call the United States? Because knowing full well the United Nations had given David, when his appointment, is that he was free from politics, that he, in essence, had the responsibility to prosecute those of the greatest responsibility. I think that was the term.
Prosecute those who bared the greatest responsibility.
That's under the statute of the Special Court for Sierra Leone.
Mm-hmm.
And he'd presented his initial facts to the court. The court had granted him an indictment. They kept it sealed until a specific time. But it was also sealed from the United States government. So at some point, did David get on the phone and say, hey, guess what? I am now unsealing this indictment. I am going to serve a head of state, and I'm giving you, guess what, guys?
When that indictment was unsealed, I don't know that the U.S. government was informed before it was unsealed and made public. No, I just don't. I don't know that the U.S. government, I can't say the U.S. government was informed that that indictment was about to be unsealed.
Can you imagine in the executive office at some point, somebody's got to get a cable, or whatever it was at the time, it's dating me, cable. Some notification that, hey, one of your fellow heads of state just got indicted by American Chief Prosecutor David Crane for the Special Court of Sierra Leone, and if that's the first time they hear about it, there's got to be some, like, say what? Was there that kind of reaction?
Well, the U.S. government, as I recall, was part of that peace process. The unsealing, the making public of that indictment caused Charles Taylor to immediately depart the peace conference and get on an airplane just as quickly as he could and get back to Liberia before someone in Ghana might decide to indeed enforce that arrest warrant against him. And so I can say, so I would suppose that the U.S. government was not particularly happy that that indictment was made public at that moment, because again, it in some instances, I won't say derailed, but certainly slowed the peace process as they were trying to resolve the situation in Liberia. The U.S. government was had a stake in that peace conference going on in Ghana. This is my perspective from the outside.
But was there some blowback from the government, from the United States to court, to David specifically?
Not that I can speak to.
Okay. You're such a good chief prosecutor. The flashback a little bit later, Jim, is Taylor wasn't the only defendant. There were other defendants who had previously been indicted and brought to trial, and they all too weren't given any heads up, and it's sort of that Operation Justice I think about. And I'm almost visualizing a day where they're going to round up everybody at about the same time, right out of this.
Let me make one comment here. You do kind of wonder why Taylor's indictment was a surprise to people. If you look at the all of our indictments are numbered, and they're numbered SCSL 2003-1 and SCSL 2003-2, -3, all the way up to the indictments. And all of the indictments, of course, as I recall, all of the other indictments were made public really at the time, very, very quickly after those indictments were signed. And those indictments started with 2. And no one seemed to ask, where's indictment number 1? And that was a question that was somewhat bewildering to all of us, is that look at the numbers on these indictments. But at any rate, I'm sorry, back to what you were asking.
Well, that's a good.
It was just bewildering that no one said, where's indictment number 1? But that I recall no one ever did.
But in a very short order, because of at least as David explained it, there was, a lot of people in place in anticipation of a certain time when
Yes.
Operation Justice.
Operation Justice.
Go, and then it's like a sting.
The indictments were all signed on a Monday. I believe that was the 3rd of March 2003. The indictments were approved on the 7th of March. The judges were meeting in London for a plenary session of the judges. The primary purpose of the plenary was to go over the rules of procedure and evidence and to make any changes the judges saw fit to those rules. And so the indictments were signed in Sierra Leone. They were put on the airplane and flown to London. And Judge Thompson, who was the judge that reviewed them and approved them all on a Friday night, and signed and the same day, as I remember, approved the indictments and signed all the arrest warrants. They were certified copies were faxed back to us and sent back to us, and we of course had been planning for the arrest through that week in anticipation if they were indeed approved. And we had to act quickly once they were approved, because that kind of thing gets out quickly. And we certainly knew that arresting them would need to be done quickly, before wind of the indictments got out and before some of them may have disappeared. And that's what we did. They were all arrested on that weekend with some pretty intense planning, and a lot of pieces were put in place to arrest as many of them as we could simultaneously on Monday morning. And that is indeed what happened. We arrested, how many went down? I think 5 went down to Bonth Island on that first night into our temporary detention facility. They were arrested in Freetown and put on several helicopters and taken to Bonth Island.
So you had intelligence on the ground, obviously, where these people were.
We did, yes, that's right. Of course, Sam Hinga Norman, he was a sitting government official, the Interior Ministry of Sierra Leone. He was arrested in his office. I was waiting for him at the helicopter site and actually was on the helicopter with him going down to Bonth Island. I was the only attorney from the Office of the Prosecutor that went to Bonth Island with all of those that were arrested that day. And, gosh, I've got to remember, Issa Sese, Bao, Gullet, Bazi. Yeah, I'd have to go back, but I think we arrested 5 that first day.
And ultimately, how many, before you got to Taylor, how many people had you indicted and arrested?
We indicted a total of 13. We had arrested 9 by the time when Taylor's indictment was unsealed. We had arrested 9 of them, and several of them were later. 2 of the CDF accused that were former members of the CDF were arrested in late May. 5 was arrested, I think, in late March or April. I'd have to go back through the dates right now. But by the time the indictment was unsealed against Taylor, we had 9 in our custody.
And then June 4th, 2003 is when the unsealing of the Charles Taylor indictments. What's in your role as you've got? I'm visualizing these guys are arrested, they're in confinement. Now you got to sort out and actually try them all.
Well, at that time, my initial position at the special court was a senior trial attorney, and I was in charge of the trial against the former leaders of the CDF, the Civil Defense Forces. And so that was my role for the first 2.5 years, through the prosecution case in the trial against the former leaders of the CDF. It was at that time that then our chief of prosecutions left, and I moved up into the position of chief of prosecutions. I moved up into that position about 6 months, or give or take, before Charles Taylor was taken into our custody. And so that's right. We were conducting 3 trials. At first, I was in charge of one of those 3 trials. Then I said I moved up, and I was in charge of I was overseeing at that time, on behalf of the prosecutor, 3 trials, and supervising the 3 trials. And then, of course, 2 of them were finished by the time Charles Taylor trial started. And when Charles Taylor trial started, we still had the RUF trial going on, and then the Taylor trial started.
we're getting in, focusing in on the Charles Taylor trial, the other trials which all drew conclusion prior to the conclusion of the Taylor trial, were there any certain verdicts of law, opinions, which sort of created new groundbreaking areas in international law?
As far as new grounds, of course, we were the first tribunal that charged the use of child soldiers. Mm-hmm. And so that was certainly groundbreaking in that sense. No one had tried child soldiers beforehand. This idea of forced marriage as an other inhumane act, as a crime against humanity, was charged as another inhumane act under that rubric, but it was unique in the sense that you typically thought of sexual slavery and rape and those kinds of gender violence and acts, gender-based crimes. But forced marriage was we saw as unique on its own merit. And the reason why is it brought this new element into of being really not only a sexual slave, but also a domestic servant, in that under the culture, as in Sierra Leone, these women were actually made to be the wives of these soldiers. And they were expected to do what would have been all of the wifely duties under that culture, which meant to cook, to care for them, and to do all of these things in addition to the sexual element of it. Mm-hmm. And so this was something that we brought forward, and it was indeed recognized and later upheld by the appeals chamber. Not universally. There was, there's still some that would say this is just a form of sexual violence and not a crime on its own merit. But ultimately, the appeals chamber did uphold it.
Charles,
well, I guess another crime that we did, that we were, of course, the first tribunal to bring and convict for attacks on peacekeepers. Now, this was an enumerated crime under our statute, because you see our statute had war crimes, crimes against humanity, and other serious violations of international humanitarian law, that being child soldiers, for example, and attacks on peacekeepers. And we also convicted for attacks on peacekeepers.
The peacekeepers were United Nations peacekeepers?
Yes, they were United Nations. Mm-hmm.
Personally, you had to look at, present evidence, investigate, before you presented the evidence, some really atrocious atrocities. Could you describe some of that? I I realize it's amazing what happened there.
Well, probably, certainly, torture and things like that has been common throughout history. But I would say that probably one of the more horrific features of the Sierra Leone conflict was amputations, and amputating the limbs off of people literally by the thousands as a terror tactic to, of course, it's mutilation, but as a terror tactic to force the population to essentially capitulate, to essentially cede to the wants of those forces. It was used under the notion of punishing them. It was a form of collective punishment as well to the population for participating in the election process. And they would amputate. In many instances, it would be a short sleeve or a long sleeve amputation, and they would line them up, and they would line up the people under threat of being shot or death, or worse, I guess, if you could say what worse might be. and they would amputate them, and then they would tell them to go to the president, to go to the government to get your hands back. And so that's certainly, that was certainly somewhat of a unique feature to this conflict in Sierra Leone. Certainly one of the signature crimes of those responsible for the conflict in Sierra Leone. And it's, you know, the aftermath of that is just, you know, we'll live through these people, those that survived the amputations, through their lifetime of constantly needing care. And they did not limit this to age, sex, or anything. When I first arrived in Sierra Leone, I would see children as young as 3 or 4 years old. Some out in around the country, but usually in and around the amputee camps that had their limbs amputated. Usually it was hands. There were cases of feet, but usually it was hands or arms that were amputated.
You met one today.
I did meet one today. A young woman, a very lucky one, who was Mariatu Kamara, who was speaking. She was 12 years old when her village was attacked.
She was in Buffalo.
She was
in Buffalo today.
she was in Buffalo today. She lives in Toronto, but she was 12 years old when her village was attacked. Most of the villagers were killed, and her hands, both hands, were amputated. She said that at the time that they were amputated, she passed out, and she woke up sometime later, not sure how long it was, and there was no one around. So her village was burning, and she saw no other living person around her. She wondered, and finally wondered across this old man who helped her to some degree, and eventually she was led to some other women who helped her, and eventually made her way to a clinic and then to a hospital. She was a lucky one to have survived that out in the bush and to have survived that attack and ultimately received medical care before she did die.
How do you immune yourself to that?
You just think about the job you've got to do. That's really, you don't immune yourself. You don't stop thinking about it, but you focus on the job that you've got to do. Our job was to see that those responsible for it were brought to justice, and that's what you focus on.
Charles Taylor was indicted in June of 2003.
March, yes.
Yes, March of 2003. Sealed indictment in June of 2003. Yet was not apprehended and brought before you, so you could even commence a trial, until March of 2006. For the audience here, our studio audience, talk a little bit about that interim. Where did he go? What happened?
Well, he left. He left Liberia and he went to Nigeria. Nigeria basically accepted him in exile, and he went to live in a resort town in Nigeria, and that's where he stayed from August of 2003 until March of 2006. And at that time, what happened in the interim was, of course, there was, I believe, international pressure on Nigeria. There was, of course, an outstanding warrant for his arrest. There was international pressure on Nigeria to turn him over to the special court. Nigeria ultimately said that if they were requested by the elected, well, let me back up a little bit. During, of course, this time, Liberia was going through a transition. First, a transition government had come in, and eventually that transition government led to UN-monitored elections in 2005. And so they did elect a new president. The first woman president in Africa was elected in late 2005. So Nigeria finally...
That was Ellen Johnson Sirleaf.
Yes, that's right. That's right. Nigeria ultimately said that if the elected government of Liberia asked for his return, that they would return him, and and so that's what had to take place. The new president eventually did make that request for Charles Taylor to be returned to Liberia. Just as soon as that request that was made, Charles Taylor, who was sitting in a very nice exile in Nigeria, surrounded by Nigerian police and soldiers, disappeared, essentially. It's always a question whether the soldiers were there to keep him in or protect him, that probably depending on who you talk to and why they were there. But he suddenly disappeared. And he eventually, and we thought that we had lost him. We thought the president of Liberia had said that she would, had made the request that he be returned, and he was gone. We thought we had lost him. And we did find, and then we did find out, I believe it was a Wednesday morning, the 29th, I think the 29th was a Wednesday morning. We heard that he was found trying to cross the border into Cameroon from Nigeria, that he was in a vehicle with diplomatic plates on it trying to cross the border. And he was taken into custody. He was put on a Nigerian jet, and he was flown to Liberia, to Monrovia. In Monrovia, the UN peacekeeping force in Monrovia had been given the specific mandate by the UN Security Council that if Charles Taylor came under their control, essentially came into Liberia, and they were in a position to take him into custody, that they were to take him into custody and immediately turn him over to the Special Court for Sierra Leone. And that's what they did. As soon as the Nigerian jet landed, they took him off, they gave him a quick physical, and they put him on a helicopter to Sierra Leone, to Freetown.
Oh, that's such a nice, clean story, but there's so much backstory here. The prosecutor at that time, David Crane, had left. His successor, Sir Desmond de Silva, and should you ever choose to go onto YouTube and type in Sir Desmond de Silva, this guy is right out of Central Casting for me. He's got the greatest British accent, and he told the story that when Taylor was on the lam, he, through back channels, was working with the United States government because I think it was the Nigerian president was in the United States and was trying to get an audience with President Bush. And unbelievable, Desmond de Silva and others worked through the executive department, State Department, to make sure that did not occur, and that was used as a bargaining chip, saying, you aren't going to see the president unless somehow this guy who just took off in your custody is found. So amazingly.
Shortly after that, he seemed to have been found. Yeah. Yes.
Praise Jesus. And Sir Desmond tells that story wonderfully. Also, at that time, Sir Desmond de Silva, while he was on the lam, and not knowing exactly the conclusion of the story, was having dinner and drinks with you, and then ultimately with himself.
Well, we were certainly a little depressed when we thought he had disappeared, and that we indeed wouldn't, because we seemed to be this close, and we certainly, throughout 2006, we certainly felt that that the climate was changing, and that indeed Charles Taylor may there may be an opportunity for Charles Taylor to come into our custody. It was at this time in January. We had been, of course, by the time Charles Taylor was in Nigeria, we had 3 other trials going on, and we were not a court that had a generous staff, to say the least. We had a skeleton staff. Our court was always concerned about funding, and we tried very, very hard to have as lean of staff as possible. Some would have called us anorexic as opposed to being lean, but we were focusing on 3 other trials. When we started to see the mood change, and of course we had a new president in Liberia, and we started to get hopeful that Charles Taylor might come back, we asked Brenda Hollis, who is now the current prosecutor, to come back to the court. She was there in the initial months and helped draft the indictments in the first instance, and we asked her to come back to the court, and she did in January 2006. And she started reviewing all of our evidence, started reviewing the case against Charles Taylor and bringing it together. We had learned an awful lot in those last few years, and we had been conducting 3 other trials. And we had seen how the evidence came out in those trials. And so we did a very, very careful review of the evidence and of the existing indictment against Charles Taylor. And that was when we took that indictment and we amended it. We streamlined that indictment. We reduced it down to 11 counts. We reduced some of the crime base that had been initially charged in the first indictment, again, to make it a much cleaner, leaner indictment in many respects, again with an eye towards, if he did come into our custody, with an eye towards making it a more streamlined trial as well. We learned a lot of lessons. So we did amend the indictment. The indictment was amended shortly before Charles Taylor came into custody. And so we were very, very hopeful that that would happen. And eventually Brenda stayed on and, of course, led the prosecution team in the trial of Charles Taylor, and then ultimately became the prosecutor when Stephen Rapp left.
So here we are in 2006. Things are happening in Liberia. You know that all of a sudden that he's going to be put on a plane. He's being brought into Freetown area, but you're not sure exactly where he is, because at some point you don't know whether he's going to land at your compound or another compound. You really don't know where he is. So there's a gap in time where you say, where the hell is this guy?
We didn't. We were very fortunate that we had 2 investigators in Monrovia at the time he was flown into Monrovia conducting other investigations, or obviously related to the Taylor case, but we had 2 investigators there. So when we got the word that Charles Taylor was on an airplane on his way to Liberia, they went to the airport, to Roberts Field in Monrovia, and they were there waiting on the ground. And so we had first-hand reports at that time that he had arrived and was being placed on a helicopter, and they came on the helicopter with him. But that's right. In anticipation that we would need in the court, the registry, in anticipation early in that year that we might need a helipad on the court compound, started building one. And the helicopter was being built and had just been completed within days before he came into custody. But we didn't know if they would land on our helipad or if they would go to the UN helipad that was probably 4 or 5 miles away in Freetown. And so we didn't know until we were at the court, until 3 helicopters came over the hill and started circling the court compound, that he would indeed come to our helipad. And 3 came over the hill, 2 of them circled, the 3rd one landed, and Charles Taylor was on that helicopter. When that helicopter landed, we were, of course, several of us were right there. Brenda Hollis, myself, and others. Desmond De Silva, the prosecutor at the time, were right there when he came down. And after the helicopter landed, of course, the rotors shut down to where you could hear. But we heard all of this cheering and clapping, essentially. And we didn't know what it was. We started looking around, and we realized that the streets around the court were lined with Sierra Leoneans. Obviously, word had gotten out that he was coming in. On the one side of the court, there was rooftops that they were lined on, and when his helicopter landed, they started cheering and clapping. And we didn't know they were there. We, of course, were very focused on our work inside the court compound, not really observing what was going on outside the court compound. But word had gotten out that Charles Taylor was on his way, and people celebrated when Charles Taylor came into our custody and landed at the court compound.
You've been chasing this guy for some time. When you finally eyeball him, what do you think?
Well, probably, I remember him, I don't remember him saying much. I do think there was certainly a look of shock on his face as the charges were read to him and his rights were read to him. He was very quiet, responded to the questions that were put to him, but he did not say anything extra. And it was, I would, in my opinion, it was a look of disbelief that he was sitting there in that place at that time.
At that moment, did you realize that you were really starting a process of trying the first head of state, really, since the Nuremberg trial? Did that sense of history at all kick in?
We knew it, but you don't think about it. I mean, we were focused on the job that we had in front of us. And so I mean, I would say that we all appreciated what was happening there, but it was not something that we were thinking about.
Part and parcel of your case against Charles Taylor dealt with generically using the term blood diamonds. And there's been movies about that and a lot of intrigue about blood diamonds. Explain that to the...
Well, I mean, certainly those, you know, the impression that you always get, or that I feel come out of a lot of the reporting on blood diamonds and the movies about blood diamonds, is that the conflict was about diamonds and about acquiring diamonds. And I never, from my time there and as close as I was, the conflict was not about diamonds as such. Diamonds were a means to the end. The conflict was about power. And the conflict was about a few who wanted to control that region, Charles Taylor being one of those, in my opinion, who wanted to control not only Liberia, but that entire region. And diamonds were a means to that end, because of the way diamonds could be taken from Sierra Leone and the way they were mined in Sierra Leone in such a way that it only took a shovel and forced labor to do it, which forced labor, of course, was something that we charged and convicted on. But that's all it took to acquire the diamonds. And at that particular time, selling these diamonds on the black market was very easy. And you had a lot of buyers out there who were more than happy to buy those diamonds and to take those diamonds. So diamonds were a means to the end. They were a means for these people to fund the conflict, to fund their ambitions of controlling that region and the power that came with it. Controlling the people, controlling the resources throughout that region, whether it was diamonds, whether it was minerals, whether it was timber, to controlling that region, and the power that came along with it and the money that came along with it. And so diamonds were the most easily obtained and transferred and lucrative in that sense, that you could very easily mine the diamonds out, take a mayonnaise jar of diamonds that was worth an awful lot of money, and transport it out and sell it on the black market and fund the weapons and ammunition and other things you needed to carry out your ambitions in the area. So much more than, I mean, there's other resources there, but they were harder to mine. Timber is, of course, much more labor intensive and moving it out. And so diamonds were the means to the end.
Diamonds were used principally to purchase arms, but also, in one instance, attempted to purchase favors. And why don't you, because I know, the folks here are most interested in when you were able to get to the stand Naomi Campbell. Why don't you talk about that?
Well, it had certainly come to the prosecution's attention that that Naomi Campbell may be able to provide evidence that Charles Taylor was indeed in possession of raw uncut diamonds, which he had claimed he never had been, and that at the time he was in possession of those diamonds, that corresponded to a arms purchase that was made. Our case was that he indeed facilitated that arms purchase, and those arms were ultimately delivered to the rebel forces in Sierra Leone. And so that's, I guess, the just behind it. And it was very important. It was significant for us to provide this evidence that Charles Taylor had been indeed in possession of raw, uncut diamonds in this time period and in this place. Those were all very important facets. Naomi Campbell was at Naomi Campbell and Mia Farrow, and Naomi Campbell's agent, Carol White, was assisting then.
Not our Carol White, by the way.
Not our Carol. That's right. That's right. That was assisting at that time President Nelson Mandela in South Africa launch a charity, and they were at his home, and they at that home for an afternoon event and an evening meal. And Charles Taylor was in South Africa, then president of Liberia, and he essentially showed up at Nelson Mandela's home. And throughout the course of that evening, from our evidence, struck up a conversation with Naomi Campbell. And at some point in that evening, promised to provide Naomi Campbell with diamonds. And later, after the evening had broken up, and Mia Farrow, Naomi Campbell, and Carol White, Naomi Campbell's agent, had retired to the guest house, two men showed up, indeed with some package of, as Naomi Campbell described it, I think she described it as rough or dirty pebbles, might have been the word she used, this package of dirty pebbles, and they gave them to Naomi Campbell. And of course, this was important for us because this provided additional evidence that indeed Charles, because this, as I said, this corresponded with an arms shipment that had been delivered, and so this provided additional evidence that Charles Taylor was indeed purchasing and providing arms to the rebels. Just another little piece of the puzzle that puts him in South Africa, where the arms originated, at the right time, with indeed raw diamonds that were used throughout the conflict to purchase these kinds of arms purchases. And Naomi Campbell, we subpoenaed Naomi Campbell to come and testify. Mia Farrow came and testified, and we didn't need to subpoena Mia Farrow. She came and testified. There's certainly, there were portions of Naomi Campbell's testimony that we questioned whether she was telling the whole story of what happened that evening. But certainly the evidence that we had hoped to come in did come into the trial.
And you didn't mind all the publicity, did you?
That was, you know, they were there for that's right. We had as much publicity when Naomi Campbell came to testify, if not more, than we had throughout the trial. And, you know, the satellite trucks, this trial, of course, took place in The Hague. We haven't really talked about why it took place in The Hague instead of in Sierra Leone. But satellite trucks lined the streets. We had, you know, legions of reporters there covering it, and brought a lot of attention to the trial. Now, you know, they may have all been there for the wrong reason, or at least from our perspective, the wrong reason. They were there for Naomi Campbell rather than to report on the trial itself. But in the end, the trial did get reported on again. And in most cases, these new organizations would provide some backstory to why Naomi Campbell was there, which again brought the conflict of Sierra Leone into the public eye. And so the terrible things that happened in Sierra Leone, the fact that this trial was going on and that a former president was being tried, all brought that into the focus, international focus again. And so that was good. That was good. It brought again into the public eye the terrible things that had happened there, and that these things are still happening in many other places in the world today. And so for that reason, all of the press coverage was good. I wish they had come on their own just to show what was going on and what had happened in Sierra Leone, but Naomi Campbell brought them there, Mia Farrow brought them there, and that was fine.
On April 26, 2012, was the conclusion of a nearly 6-year-long saga. A 3-judge panel at the Special Court for Sierra Leone, sitting in The Hague, the Netherlands, unanimously found the former Liberian president, Charles Taylor, guilty of aiding and abetting 11 crimes, including murder, rape, sexual slavery, and forced labor. When you're hearing them read the actual judgment, and I know there was a lot of anticipation. A lot of people went back. David Crane, Stephen Rapp, all went back to hear it. And you didn't know ahead of time really where this was all going to come out. What was your sense listening to it?
Well, the judges certainly have a way of, you've got to remember that the ultimate judgment was 2,600 pages long. And so they read a summary of the judgment. And they certainly had a way of reading it to keep you wondering and guessing through. They read it, I think they went on for about 2 hours, or at least an hour and a half. And the first hour of it, they certainly kept you wondering which way they were going to go. And so you're certainly sitting on the edge of your seat. Finally, I don't remember what point it was, but finally at a point of reading that judgment, it became quite clear that he was not going to be walking away from that courtroom, that he was going to be going off from prison. And so certainly there was a great sense of relief that you felt. We charged him with, in the end, he was charged with 11 counts of war crimes, crimes against humanity, and other serious violations of international law. He was convicted of all 11 of those counts. But to convict them, you have to find essentially the mode of responsibility or the reason that you're convicting them. We allege that he had ordered the crimes to be committed. We alleged multiple modes of liability, but specifically that he had ordered, that he had aided and abetted, that he had planned, that he was, of course, guilty as a superior, and many modes. Ultimately, they only found him guilty under the modes of aiding and abetting and planning one of the most horrific campaigns through the conflict. So the judges spent the first part of reading the indictment really saying why he was not guilty of these other modes of liability. And so again, they kept you wondering right up until the end on was he going to be found guilty, and of course ultimately he was on all 11 counts, and that is what was important.
David Crane, in a post shortly thereafter, read, "The judgment sent out a clarion call to all the world's tyrants, thugs, and dictators that no longer are they immune from accountability for killing their own citizens. If there is a political willingness to take them on, then the jurisprudence stemming from this case will be a cornerstone upon which a case will be built for a tyrant to face justice." The key to that is political willingness. Do you get a sense now that this is almost history? The appeal process, sentencing, he got sentenced to 50 years. Now the appeal is being considered and will probably come out a year from now, maybe?
Hopefully by the end of the year. It should be this fall, the end of the year at the latest.
Where do you get the sense that the political willingness is generally? I mean, this is a capstone case. Charles Taylor, Karl Donitz of the Nuremberg trial. What's the legacy here?
Well, I think the legacy certainly is that there is a political will to this. You look at, of course, the Milosevic trial. Had it come to an end, had he not died before the trial was completed, he would have been the first head of state since Nuremberg. You've got another trial in the Yugoslavian Tribunal, the president of Bosnia on trial, the general on trial. So you see it going on there. You're looking back in Cambodia, and you're looking at the trials that are going on, or the two that have gone on in Cambodia. So you look at the indictment against Bashir out of Sudan. So you are seeing a political will to move in that direction. For some, it will probably never be moving fast enough. For others, it's probably moving too fast. But yeah, I think you are seeing a will. You're seeing the biggest probably downside of international criminal law is it's expensive. It's not cheap. It's also time consuming. These trials take an awful long time. But the will seems to be coming around. You saw the U.S. and the willingness of the U.S. to see the Sudan referred by the Security Council to the ICC, which resulted in that indictment. The true test will be eventually what comes out of Syria, to see what happens there. Whether you see, I can't tell you, I don't know that I want to speculate on what form it's going to take. Will you see additional ad hoc tribunals set up like in Sierra Leone and Cambodia, and you've had in Rwanda and Yugoslavia? Or will you see more movement in the direction of the International Criminal Court? But the political will is changing. It is there. You've broken a huge barrier that existed since the end of World War II. And that was a significant step.
Speaking of end of World War II, you are now the president CEO of the Robert H. Jackson Center. The chief prosecutor of the Nuremberg trials was Robert H. Jackson. In 3 minutes, what's he mean to you?
Well, certainly none of this work, none of the things that I've done for the last 10 years or that the other tribunals have done and are continuing to do and move forward would have been possible without what Robert H. Jackson did. Without his courage to come forward and say, first of all, that the rule of law is the rule that's got to be applied here, and laid a framework to do that. And that framework is what it doesn't look exactly like it did then, but you can certainly see the evolution from Nuremberg to what we have today. The evolution is there, it's clear. And he set the framework for that. And, to me, he is the most important figure, and I say this not just because I'm the president of the Robert H. Jackson Center, but to me, he is the most important figure in international humanitarian law and these trials. And I think one of the toughest jobs as president of the Jackson Center is making sure that side of Jackson's life does not overwhelm an equally important side of Jackson's life and what he did on the U.S. Supreme Court. When it came to his work on the Supreme Court and his writing on the U.S. Supreme Court and the opinions that he was involved in and setting the stage, whether it's from presidential power or social justice, whatever the case may be.
This is terrific, and we are nicely running out of tape. So, ladies and gentlemen, Jim Johnson.
Yeah. When you shut that off, I'll answer a few of your other questions.
Yeah, I know. I'm sure you will.
Uh-huh.